Welcome back to the Deep Dive, where we take one thorny issue, a stack of research, and turn it into something you can actually wrap your head around. Today we're tuning into the power of the punchline, the sting of satire, and why in a thriving democracy, sometimes the sharpest insights come wrapped in a joke.
That's right. We're diving deep into the recent whirlwinds surrounding comedian Kunal Kamra and what it tells us about the ever-shifting boundaries of free expression in India. It's a case that's sparked debates from the comedy club to the courtroom, and, well, we're here to make sense of it for you.
And to do that, we've assembled a really compelling set of sources. Think of it as your cheat sheet to being in the know. We've got a legal breakdown from Columbia University's Global Freedom of Expression, offering a kind of bird's-eye view of the constitutional questions. Then we're looking at transcripts from Dhruv Rathi and Akash Banerjee, two prominent YouTube voices offering their perspectives. We've also got boots on the ground reporting from Times Now on, well, let's just say Kamra's bottom line, plus in-depth legal analysis from Bar and Bench, opinion pieces from the Indian Express, a Reddit thread capturing the public pulse, a report from Mint on a particular apology, and finally, Prakash Raj weighing in with a powerful defense in the Indian Express.
So a truly multifaceted look at this. Our mission for you is to dissect the sequence of events, illuminate the core legal and constitutional fault lines, explore the diverse reactions and viewpoints, and ultimately understand the broader significance for free speech and, the health of democratic discourse in India. And we promise we'll keep it engaging without drowning you in legal jargon.
All right, let's set the stage. What lit the fuse on this controversy? It seems Kunal Kamra's stand-up show, Naya Harad, and a video that dropped on March 24th were the starting point. What exactly stirred the pot?
Well, it boils down to Kamra's use of the terms Gadar and Dalbadlu, essentially, traitor and defector in his act and in his song in the video. Now, he didn't name names, but the speculation was immediate and widespread. These were like thinly veiled jabs at Eknath Shinde, the Deputy Chief Minister of Maharashtra, given his rather dramatic political switcheroo.
Right, those are politically charged words with real weight in the Indian context. And it sounds like Kamra wasn't looking to smooth things over. He reportedly stood his ground, refusing to apologize, and even posting online that he wasn't afraid of the mob. That's a pretty bold stance to take.
Absolutely. And as we often see in these situations, the reaction wasn't just verbal. The Habitat Comedy Club in Mumbai, the venue for Kamra's show and likely the video shoot, was vandalized by members of the Shiv Sena. A pretty visceral response to jokes, wouldn't you say?
You're not kidding. Going after the venue that sends a chilling message. It didn't end there, did it? The legal machinery started to turn.
Indeed. FIRs, that's First Information Reports, the first step in a criminal investigation, were filed against Kamra in Mumbai. But what's particularly noteworthy is the scope of the investigation. Police reportedly questioned attendees of Kamra's show, even the camera person and the venue staff. It suggests a really intense level of scrutiny directed at this one comedic performance.
Which brings us to Dhruv Rathi's commentary. His YouTube video transcript really zooms in on this incident, the vandalism and the alleged threats that Kamra faced. He also highlights a quote from Eknath Shinde. Action has a reaction.
That quote is key. Rathi interprets it as essentially justifying the actions against Kamra, framing the entire episode as an instance of what he terms gundaraj, a kind of strong-arm rule, and the silencing of dissenting voices. He draws parallels to other comedians who face similar backlash for their work, suggesting a pattern.
And Rathi's transcript also points out that while there were detentions of Shiv Sena members involved in the vandalism, they were reportedly quickly granted bail. It raises questions about accountability and the legal consequences for such actions, doesn't it?
It certainly does. And this whole sequence of events, the initial jokes, the reaction, and the perceived lack of serious consequences for the vandalism really laid the groundwork for the significant legal challenge that followed. The feeling that free speech was under threat fueled a public interest litigation, EIL, against the information technology rules, specifically the 2024 version.
Okay, let's unpack this legal battle. The Columbia University analysis really shines a light on Rule 3.1, BV, and its potential reach. This rule essentially gave a government-established fact-checking unit, let's call it the FCU, for short, the power to identify and flag online content about government affairs as fake, false, or misleading, potentially leading to its removal. That sounds like a pretty significant shift in how online content is regulated.
It is. The petitioners, including Kunal Kamra and various media organizations, argued that this rule strikes at the heart of the fundamental right to freedom of speech and expression, guaranteed by Article 19(1) of the Indian Constitution. Think of Article 19A as the bedrock of free speech in India, ensuring the right to express oneself freely. The core argument against the rule was that it would create a chilling effect on speech. Social media platforms, wanting to avoid losing their legal safe harbor protections under Rule 7, which previously shielded them from liability for user content if they followed certain guidelines, would be incentivized to take down anything flagged by the FCU, leading to widespread self-censorship.
This challenge landed in the Bombay High Court, which delivered a split decision, right? That's always fascinating.
Yes, a 2.1 verdict. Justices Patel and Chandorkar deemed the rule unconstitutional, while Justice Gokal upheld its validity. Justice Patel, in his judgment, argued forcefully that the rule tramples on Articles 14, equality before the law, 19(1)A, freedom of speech, and 19(1)G, freedom to practice any profession or occupation of the Constitution.
Wow.
He stressed that it places an unreasonable burden on digital intermediaries, essentially turning them into censors and stifling the free exchange of ideas vital for a functioning democracy.
Justice Patel also raised a red flag about the lack of checks and balances, pointing out that the government-appointed FCU could act without any real oversight, effectively making the government both the accuser and the judge. That strikes at a fundamental principle of fairness, doesn't it?
Absolutely. That's a core tenet of natural justice, the idea that you can't be the judge in your own case. Justice Chandorkar, agreeing with Justice Patel, echoed these concerns. He also highlighted the inherent vagueness of the rule and the lack of clear procedures, arguing that it unduly restricts freedom of expression and creates a significant chilling effect by being overly broad and open to, well, arbitrary application.
Now, on the other side, Justice Gokal argued that the rule is a reasonable restriction designed to curb the spread of misinformation, which she believes is a legitimate aim under Article 19(2) of the Constitution. Article 19(2) outlines the permissible grounds for restricting free speech, such as in the interests of public order or national security. She also suggested that intermediaries still have options, like using disclaimers, to comply with the rule.
Yes. Justice Gokal contended that the rule includes sufficient safeguards and aligns with previous legal precedents that have upheld restrictions in the interest of public order. She also drew a distinction between this rule and Section 66A of the IT Act, which was famously struck down in the Shreya Singhal v. Union of India case for being too broad and vague.
Right, I remember that.
Then having the potential to stifle legitimate online expression, a concern echoed in the current challenge. Justice Gokal argued that this new rule doesn't impose automatic penalties without judicial review.
However, the majority justices Patel and Chandorkar really homed in on the potential for misuse and the impact on free speech. They both emphasized that the term business of the central government is just too broad and ill-defined, falling short of the standards for permissible restrictions on speech under Article 19(2).
Precisely. Their argument was that this vagueness harks back to the very issues that led to the downfall of Section 66A of the IT Act, which was also criticized for its potential to be used arbitrarily to suppress dissent. Furthermore, they underscored the worry that the FCU, being a government entity, acting as both the identifier of fake news and the trigger for its removal, fundamentally violates the principles of natural justice.
And the Columbia analysis points out that this split verdict is now under appeal in the Supreme Court.
Yeah.
So this legal drama is far from over.
That's right. And importantly, the Supreme Court has put a hold on the implementation of the SCU pending the final outcome of this legal battle. So while the rule is on the books, its teeth are currently capped.
This whole legal back and forth really highlights the delicate dance between the government's need to tackle misinformation and the fundamental right to speak freely, especially when it comes to criticizing those in power. It's a tightrope walk, isn't it?